Indigenous peoples first went to the UN, of course, they had no access because the UN itself is essentially a club of governments. That's what it is. And so after some repeated efforts in the late 1970s, that barrier was broken down so that Indigenous peoples could go to the UN. And what came out of that was an understanding that in all the human rights work that had been done post-World War II, an area that had not received hardly any attention at all was the widespread discrimination and dispossession and marginalization of Indigenous peoples all over the world. And then it was recognized that, in fact, not only had not attention been paid there, but in fact, Indigenous peoples probably were the ones that suffered the most human rights violations all over the world and were continuing to suffer those violations. And so then they began, because really the UN does a lot of standard setting, so they began this standard setting work. What would be the standards if we were going to talk about human rights for Indigenous peoples? And out of that, the declaration grew. And there was two different working groups. The first one was established in the early 80s. And out of that working group, the original draft came. And then the second working group was working with the text that had come out of the first one. At a certain point in the process, the Indigenous representatives were getting really frustrated with states driving the train. And so it was agreed that, in fact, that was entirely inappropriate. And Indigenous peoples needed to have the same space in the room that states would have if this was to be a legitimate exercise. And so they changed what they did to get around the UN rules, around the way the UN has meetings work, is they made them informal meetings. So for a great length of time, they were informal meetings. And in that way, Indigenous representatives could have the same opportunity to be speaking in the meetings and have the same input into the negotiations as member states could. And that made it, and that's one of the reasons why it took so long. So it was more than 20 years, and which makes it the most discussed instrument in the history of the United Nations. And the reason is because this method of work was created where Indigenous reps had this space, which also is a unique feature for a human rights declaration, that the rights holders were having the same space at the table as the governments of the world. And in this informal context, the governments agreed. The UN likes to adopt everything by consensus when they can. So they agreed that consensus included the Indigenous delegates. So it wasn't just state consensus they had to reach. And that was really difficult. And when I came into this process, I thought, in fact, the very first meeting I went to, I thought to myself, we will never have this declaration because states were so far from where Indigenous peoples were in what they wanted to see in an international instrument. But I would say there's a lot of factors that brought it together so that we could have one. And some of it was, a large part of it was the very hard work that Indigenous peoples representatives put in, and some states who really invested the hard work in trying to understand what Indigenous peoples were saying, and then work also with their other colleagues. Because the Declaration itself doesn't create new rights. The Declaration is an expression of existing international standards, international human rights law, and then through the lens of the experiences of Indigenous peoples around the world. So it wasn't about some higgledy-piggledy, let's just create rights for Indigenous peoples. It's not what it was at all. And when states could see that, in fact, these are human rights standards you are already supporting in other forums, and now we are articulating them through the experience, the global experience of Indigenous peoples, then slowly states began to get on board. And so a momentum was built. The original text was adopted in 2006 by the Human Rights Council. And in the normal course of events, that text would have been adopted by the General Assembly that fall. But there was some states, and Canada was one of them, that were really opposed. And so they lobbied states that had not participated in that 20-year process to have them go to New York and say, well, we don't really know much about this. We need some more time. So even though 20 years seems like quite a lot of time, what happened at the General Assembly that fall is essentially they said, okay, we're going to give you, it worked out to be about 10 more months to make revisions to what has been adopted at the Human Rights Council. And that's really unusual. But we moved from Geneva to New York. It became very political. Canada was one of the countries that was really heavily lobbying against it. And I worked with some colleagues. I worked with a colleague from the Grand Council of the Crees and a colleague from Amnesty International. And the three of us did a lot of work in New York that year, trying to work with the states to get them to see, what it was and why it was important and why they could support it. And in the end, there was a large group of states that were supportive and had said, we didn't have the same kind of process in New York where the consensus was going to include the Indigenous representatives. But there were several states that were supporting Indigenous peoples. And they said, when we get to the end game, if you don't agree with the text, we will not allow it to go forward. But everybody also knew when we get to the end game, if it doesn't go forward, the work is done. Nobody's going to go back to Geneva and start over from trying to fix it. Like it's a now or never situation. And so that text that was adopted in Geneva had 9 amendments. And I think that at the same time that they weren't, that isn't what Indigenous peoples wanted to see. There was a period of time given. There was a really incredible networking by the Indigenous caucus all over the world with key representatives representing different countries and different regions so that information could go out and come back really quickly. And so the decision was made that a few of the amendments actually improved the text. A few of the amendments were reasonably neutral. They didn't do anything. And a few of the amendments were really not desired, but they weren't negative enough to make people say, we can't go forward with this. And so the text went forward, and that text was adopted in 2007. And that was the text that Canada voted against. And Canada, Australia, New Zealand, and the United States. And all 4 of them have reversed their positions, which makes it a consensus instrument. And that's important in the UN. So when an instrument is consensus, it has more weight, it has more validity, it's going to get used more. And since then, in the 12 years since, we've had at least 10 resolutions of the General Assembly by consensus affirming the declaration. So in fact, it's really very solidly grounded in the UN system now. They have a system-wide action plan for the whole United Nations to be using the declaration. It's just understood at the international level that these are the standards. When we're talking about Indigenous people's rights, these are the standards.